Hi, my name is John Skiba, and I'm an attorney in Arizona who helps people fight abusive creditors. Social media can unravel your FDCPA claim or deep six a possible defense in your debt collection lawsuit faster than you can say Facebook. It's easy to get a false sense of privacy when we're chatting away with family and friends on social media. But social media can be used for more sinister purposes, such as, well, debt collectors that are trying to locate you. I know this may seem kind of paranoid, and if I hadn't heard about it right out of the debt collector's mouth, or at least out of their attorney's mouth, I probably wouldn't believe it either. But recently I came across a podcast that is put out by attorneys for debt collectors in the debt collection industry. One of their most recent episodes was focused on providing information to debt collectors on how debt collectors can deal with FDCPA cases without going to court. The first thing that these lawyers said they did when they received a lawsuit alleging that a debt collector had violated the FDCPA was to check out the plaintiff, i.e. you, on the various social media platforms. What are they looking for? To see if you're talking about the lawsuit, talking about the debt, to see if you have any embarrassing photos or background. They check out to see if you filed bankruptcy before or if you have any type of criminal history. The idea being that if you have something that's embarrassing your background, they'll exploit it and try to discredit you in your FDCPA lawsuit. Sometimes when a debt collector agrees to pay a settlement, there will be an agreement between the parties that the settlement will be confidential. If you go out and blast your hard-fought victory on Twitter, you could and likely will put the entire settlement in jeopardy. Recently, there was a case in Florida where an employee brought a suit against his prior employer. A settlement was reached for $80,000. However, part of the settlement was that the parties agreed to keep all of the terms confidential. Well, after the settlement was finalized, the employee told his teenage daughter about the settlement, and she immediately proclaimed this victory on Facebook. Here's what she said specifically. Mama and Papa Snay won the case against Gulliver. Gulliver is now officially going to pay for my vacation to Europe this summer. Suck it. Nice. Actually, not nice. The attorneys for the employer found out about it, the judge found out about it, and the judge voided the settlement, and the family had to pay back the $80,000. That's an expensive lesson, but one that you should learn from. If you're involved in a debt collection lawsuit, or you believe that you have an FDCPA claim against a debt collector, it's best to keep this information between you and your attorney. Thanks for watching.